Good morning. Good morning, everyone. Call the meeting to order. This is our 8th meeting. And Mr. Clerk, please call the roll.
Representative Banta.
Present.
Representative Bauman.
Present.
Representative Blanton.
Present.
Representative Burke. Representative Dietz.
Here.
Representative Flannery. Representative Griffey. Representative Kulkarni. Representative Lewis. Representative Maddox. Representative Marzian. Representative Moser. Representative Nemus.
Here.
Representative Petrie.
Here.
Representative Roberts.
Here.
Representative Stevenson. Representative Whitaker. Representative Williams.
Here.
Representative Wilson.
Here.
Vice Chair Decker.
Present.
Chair Elliott.
I'm here, and we have a very lengthy agenda this morning. We do have a quorum, so we're duly constituted to conduct business, but we have 8 bills, so I'm going to limit the discussion on the House bills at least to 10 minutes per bill, and then hopefully at 11 o'clock we'll be able to hear the Senate bill that's listed on the agenda. So the first bill we will hear, we're going to go out of order, is House Bill 442, an act relating to privacy for attorneys involved in criminal actions. Representative Wilson.
Thank you, Mr. Chair, and thank you for hearing us first.
And there is a committee substitute. There's a motion, a second. All those in favor, please say aye. Aye. Those opposed, no. And the sub is adopted.
Thank you, Mr. Chairman. I'm Nick Wilson. I'm the state representative for District 82, Whitley County, and parts of Laurel County. And I'll allow my guest to introduce herself and explain what the Safe at Home program is.
Yes, Jennifer Sketchfield, Assistant Secretary of State. One of the things that you all did in 2021 was to expand our Safe at Home program, which helps to protect victims of domestic violence. One of the things that we've seen increase over the last decade is dangerous doxing, other things that have happened to public servants, as well as judges, as well as prosecutors and criminal defense attorneys. I had mentioned to Representative Decker about trying to expand Safe at Home to protect these other classes of persons, and I think Representative Wilson had his bill to protect the persons in judicial offices, and it kind of was a perfect mirroring of the ideas to bring this forward as something that will help keep our public servants safe. Yes, a little bit about how it operates. The Safe at Home program, after application, a person is issued an ID card. That ID card can be used at local, basically it's county level, state level, city level agencies, government agencies. You can use the Safe at Home address as your public address. The only thing it does not protect is if you own real property. Unfortunately, we don't have a way yet to do that correctly so that title searches and whatnot can be conducted. But it protects your address from the public, keeps it away. One of the other things that we did internally for the victims that applied under the domestic violence is we offered them the opportunity to enroll in Delete Me. And Delete Me is a program that helps. We've all looked on the internet for somebody's address, somebody's phone number, and you have something come up with white pages that has, we think this person might live here, here, or here. What Delete Me does is it removes that information from the public domain on the internet. We offer that to the domestic violence survivors free of charge. I think we can extend it to the people in the different classes, probably for about a $75 a year charge. So that would be something available.
Yeah.
Turn my microphone on. Motion in a second. You have anything, Representative Wilson?
No, Mr. Chair. This bill just adds prosecutors and public defenders to that program that she just described. I'd be happy to answer any questions. On the floor, I'm sure I'll go through some of the cases that we've seen where prosecutors have been threatened and other lawyers as well. But in interest of time today, I'll just be happy to answer any questions and ask for a vote.
Well, I think it's a worthy idea, and prosecutors have a very dangerous job in the state, and you're also adding certain defense attorneys as well. So I think they have a dangerous job depending on their situation as well. So Representative Banta, you're recognized.
Yes, I love this bill. I'm going to be a yes. What about family members? What if you have an unusual name and they Google your wife or your significant other or whatever?
That's something we've considered. The Secretary of State seems to believe that the program can handle more participants. I think at this time we're just going to start here, and hopefully it can expand in future sessions.
Thank you. So we have a motion and a second. Representative Marzian.
Thank you, Mr. Chair, and I probably should know this, but you mentioned doxing. Tell me what doxing is.
I can take a stab at it as well. It's like a public exposure of someone's address. There have been instances where, and this sounds so crazy because it is, but it has happened where somebody can use someone's address to make a threat that would force like the FBI to bust someone's door in. I mean, you can see these things on Twitter, on people's like live streams where they play video games and stuff, where they've been doxxed, and the FBI or DEA or some agency come bust their door down. And it's treated, some people treat it as like a prank or something, but it's actually very serious, very extremely dangerous, and that's what doxing is referring to.
So the FBI comes and bursts into the victim's door.
Right. So, say someone exposes my address making a threat or some terrorism type of threat as me, then they're going to come bust down my door.
Okay.
If that makes sense.
And can I ask one other question?
Yes, please.
So the sub moves from the judge's privacy statute to the Safe at Home program. Is that correct?
Yes, ma'am, that's correct. And that's just after communication with Secretary Adams, Representative Decker, and Ms. Scutchfield that we feel like the program has been successful and
Okay.
will remain to be successful, and we're excited to see it grow. We think it's a great fit.
Thank you for that answer. Thank you.
Representative Burke.
A question, please.
Yes, please.
Love this. Really glad that you're working on this. I have a question specifically about the attorneys appointed to a panel to you spoke about public defenders. This, if I'm understanding correctly, would also apply to people who are doing that not as their full-time job. Is that right?
So the intent behind that was to capture federal public defenders.
Okay.
Because they have panels. I can speak about the Eastern District of Kentucky and London. I know they have a panel that I guess it's probably contract based, where public attorneys or I guess private attorneys, I should say, that have their own businesses, they're appointed to these panels. So we wanted to do prosecutors, we wanted to do public defenders. This is an attempt to grab all the public defenders.
I appreciate your answer, and I think that that's the right move, since not every defense attorney is a full-time public defender. So I salute that. And may I have one other question?
Yes, please.
This is a question and kind of a comment. I like it better in the judicial protection, and here's why. Rep. Banta also flagged that this won't provide the family protection the same way the judicial protection works. So that does include family members in the judicial protection law. And that's why when I was contemplating and filed a bill for legislator protections, that's where I went, was to the judicial protections, because I think that they are more robust and apply to public servants, where for me, the Safe at Home program, which is amazing, does excellent work, they're just charged with protecting a different kind of person with different needs. And so for me, it's a little bit of a mismatch. I will support it, but I'm just interested in having a further conversation as we go along.
And it can be interesting to compare the two. If the judicial's over here and the prosecutors and public defenders are over here, we may get an answer pretty quickly on which one works better.
Thank you.
Thank you. Mr. Clerk, please call the roll.
Representative Banta.
Yes.
Representative Bauman.
Yes.
Representative Blanton. Representative Burke.
Yes.
Representative Decker.
Yes.
Representative Dietz.
Yes.
Representative Flannery.
Yes.
Representative Griffey.
Yes.
Representative Kulkarni.
Yes.
Representative Lewis. Representative Maddox. Representative Marzian. Representative Moser.
Yes.
Representative Nemus. Representative Petrie.
Yes.
Representative Roberts.
Yes.
Representative Stevenson. Representative Whitaker. Representative Williams.
Yes.
Representative Wilson. Chair Elliott.
Aye. So 19 yes votes and no votes. House Bill 442 is amended by the substitute is passed with favorable expression, so congratulations. Our next bill that we will consider is House Bill 569, an act relating to designation of special judges, Representative Stephanie Dietz. And good morning, and please introduce yourselves.
Good morning,
Proceed, and I'm starting my clock, so 10 minutes.
All right,
at the
Stephanie
most.
Dietz. I represent the 65th District.
Eric Lykin, I'm the general counsel for the House Majority.
All right, good morning, Mr. Chair and members of the committee. House Bill 569 will address a dilemma that attorneys often face when a client or a client's interests may be served by asking for the disqualification of a judge who the lawyer or clients believe may have a bias for or against a particular party or issue. The only remedy is to ask the same judge to declare himself or herself biased. Far more often than not, attorneys choose not to request the disqualification rather than risk retaliation against the client, and in that case, or against the attorney in many future cases before the same court in which the attorney may practice all of their cases. Similarly, a person may have an interest in a constitutional or legal issue and believe the judge has a personal or political bias that may not affect the person in that case, but in other cases for which a precedent may be set. This bill merely gives a party to a case or a non-party to ask the independent party's review rather than a judge that meets the judicial conduct standard of an appearance of bias.
Motion on the bill, Mr.
Second.
There's a motion and a second on the bill. Mr. Lykin, you're recognized for any comments you'd like to make.
Thank you, Mr. Chairman. I'll just be here to help answer questions.
Understand. Does any member have a question or any member seek recognition? Representative Marzian.
Thank you, Mr. Chair. So you could, if you're coming before the courts, you could ask for partisan basis or partial basis? I mean, could you ask if your judge was a female or African American or immigrant? I mean, I think this could lead to some big problems that you could say, well, I don't like that judge because they could be a partial, but maybe you just don't want a woman judge or a black judge or an immigrant judge or I don't know.
This bill does not change the criteria required for recusal. So it's that doesn't change. So any reason that you can ask now for recusal, you would ask after this bill. And of course, the Attorney General and the Chief Justice are filters for that kind of thing. So they have to both determine that the judge's impartiality could reasonably be questioned is the standard, and that does not change.
Okay, one other question, follow-up.
Please.
Do many people ask now for a different judge? Yeah, do you have data on that, how many people have asked?
Well, there probably is data on how many people ask, but the problem is how many people don't ask. As an attorney, it's a very difficult question for you to stand in front of a judge and say to their face, you cannot be fair in this case. And judges are human, and they don't like that. And you have to stand in court and explain why you don't think they're fair. So, as an attorney, we have the duty to zealously advocate for our clients. But you have to take into account that the judge may take a dim view of your client, may take a dim view of you as an attorney in future cases. So it's a very difficult thing, and that's unknowable. How many lawyers didn't make that motion on behalf of clients that they should have because they feared retaliation?
I'd just like to add to that, personally in my experiences in family court, it doesn't happen often, but there's times that you need to do it. I just had this happen maybe 6-8 weeks ago, and I will say that the judge chastised me pretty well for filing the motion, denied it, and that didn't need to happen. So it is a very difficult thing for an attorney to do, is to look at the judge you're practicing in front of and asking him, because of a potential bias, that they need to recuse. So I don't think this changes, as Mr. Lyken said, the standards at all for what we're looking at. But I will say it's probably one of the most difficult things we do as an attorney is asking a judge to recuse. And I've had another attorney that probably filed that motion 6 or 7 times before the Supreme Court, and it was denied every single time. So there's times when they're just flat out denied.
And this doesn't replace the traditional process that we still have as attorneys to go to court and ask for a judge to recuse himself or herself. And part of this bill that I think is a good safeguard is that the Attorney General would vet whether or not it was a legitimate petition, and then the Attorney General would act. So that's, I think, a good safeguard so that you don't have people just filing for recusals everywhere of judges. The AG is going to vet it, and if it's legitimate, then it goes forward. If it's not, then it doesn't. Representative Roberts.
Thank you, Mr. Chairman. Just 2 quick questions. First and foremost, has the Supreme Court of the United States recently held that the 14th Amendment, both procedural and substantive due process provisions, protect the right to a fair and impartial judiciary?
I'm not familiar with a specific case, but the answer to your question is yes.
Yeah, and that would be Caperton versus A.T. Massey Coal Company, and that was 2009. Second question, has this case and instances of judicial partisanship resulted in the impeachment and removal of an entire Supreme Court bench in a neighboring state?
Yes, that's correct.
Okay, I just wanted to thank the sponsor for bringing this bill, because it's a serious problem. And as mentioned, lawyers are afraid to speak out on this issue because they know that they are at risk of judicial retaliation. This is an important guardrail to ensure that this basic constitutional right is protected. Thank you.
Representative Burke.
Thank you. I would like to ask a question, please.
You may.
Thank you. My biggest concern about the proposal here is the allowance of a third party to petition the Attorney General. So that's someone who has no skin in the case. Am I understanding that correctly?
Yes, the bill does allow any person, very often there are parties, entities that may have skin in the game, but are not in the case. So, and it also protects. A big feature of the bill is that it's the anonymity for the requester. So if you only have 2 parties in the case and one of these happens, the judge is going to know. Mm-hmm. So that's another safeguard. One, to let people who aren't in the case but really have skin in the game and may be greatly affected to file this anonymous motion, and to protect the anonymity of the requester.
Thank you for the answer. I have real issue with us maligning the entire bench and making assertions that they can't be fair and impartial when we do our jobs. They know it's our jobs. And so we often have to go argue difficult motions in front of the same judges over and over again. I think it's really dangerous territory for us to be in, to make it seem like the people who are serving on our bench are not trustworthy people, and that they can't fairly and impartially take a question of whether or not they're the right fit. So that part really concerns me.
So we are at 8 minutes and 30 seconds. So I'll recognize Representative Kulkarni.
Thank you, Chairman. I'll be brief. And thank you for bringing this bill. I understand. I think the intent of it is frightening for lawyers and clients to say to a judge, we don't think you're going to be treating this case fairly. I do have a couple of questions, and I apologize, Rep. Dietz. I was trying to catch you before, but I was running late, and I will
You have a
follow
minute,
up.
so let's.
I will follow up
10
with a few
minutes.
questions I have after the fact, but I do have one question specifically in terms of the breadth of the language. It says any person. Is that a natural person, or could that include corporations?
A person is defined in the KRS, and it does include business entities, government entities, and other than natural persons, yes.
Okay, thank you, and I'll follow up with you after. Thank you.
So the time has expired. Has there been a motion? There has been a motion and a second. Mr. Clerk, please call the roll.
Representative Banta,
Yes.
Representative Bauman,
Yes.
Representative Blanton,
Aye.
Representative Burke,
No.
Representative Decker,
Yes.
Representative Dietz,
Yes.
Representative Flannery, Representative Griffey, Representative Kulkarni,
I'm a pass for today, and I'll follow up.
Representative Lewis,
Yes.
Representative Maddox, Representative Marzian, Representative Moser,
Yes.
Representative Nemus,
Yes.
Representative Petrie,
Yes.
Representative Roberts,
Yes.
Representative Stevenson, Representative Whitaker, Representative Williams,
Yes.
Representative Wilson, Chair Elliott.
Aye. So with 17 yes votes, 2 no votes, and 1 pass vote, House Bill 569 is favorably passed. So congratulations, and thank you for being here.
Thank you.
Does any member have anyone they would like to recognize? I glossed over that this morning, and I have a very special guest with me who is sitting up here as an honorary member today of our committee, and that's Laisha Gudabanda, and I'm so happy to have her with us from Goshen, Kentucky. She's a student at North Oldham High School and a constituent of the speaker, so please make her feel welcome, and we're glad to have her with us today. The next item that we will take up is House Bill 425, an act relating to motor vehicle racing, Representative Beverly Chester Burton. And if you would please come forward and introduce yourself and I know.
Okay. Good morning. I'm Beverly Chester Burton. I represent the 44th District.
Good morning.
Jason Nemus, 33rd District. I didn't know I was going to be at the table, but she told me to come down there, and she's from Shavely.
So you're
So
gonna,
I
going to
do.
listen.
I'm going to listen.
You're gonna listen. So the 10-minute clock has started. Please proceed.
Thank you, Mr. Chairman. House Bill 425 is the same bill pretty much as, well, it is, as 465 last year before we ran out of time. It made it over to the Senate, and at that time, the time expired. But basically, House Bill 425 puts Louisville ordinance into state law with the first offense of $1,000 fine and 6 months impoundment, and the second offense penalty added would be the $2,000 fine and or up to 30 days imprisonment with vehicle forfeiture. The proceeds from the auction of the forfeited vehicle will go to the victims, the Crime Victims Compensation Board. And we received questions last year regarding all of the illegal drag racing from not just from Metro Council, but also from some of the other small cities within Jefferson County. And so I thank my gentleman here from Jefferson 33 for being a primary sponsor with me on this, and I'll let him have a few words.
I won't say much, Mr. Chairman. I know time is short and we've already passed this bill through last year, but this is a big problem. It's getting worse. And so this is an issue that our police chief has brought to us as something that would be helpful. As the sponsor said, that the car can be sold that goes to auction, or it can be destroyed, and probably most of them will be sold. But I think, people, they really care about their cars that they're racing. And I'd like to see some of them have to see that the thing they care so much is putting all of us in danger, crushed in front of them, and so that maybe they'd stop racing.
Motion on the bill.
There's a motion and a second, and I may want to come to one of those if you get it scheduled.
Okay.
That's right.
Representative, I may
We'll,
watch
we'll
that.
send the invitation.
You have been such a strong advocate on this issue, Representative Chester Burton, and I know I've heard from the mayor last year, and there was a big issue in Jefferson County. So, thank you for your advocacy on this, and hopefully the Senate will see the wisdom of it and pass it like we have through the House. Any member seek recognition? Representative Lewis.
Thank you, Mr. Chairman. I would just ask, what constitutes drag racing? Is like if I pull up to a light and I'm revving my engine, or maybe I just go too fast, or is it a formal event? But what's the definition of drag racing?
So that's not changed under the bill. It violates 189.045. I don't have that in front of me.
That's fine, sponsor. I'll
Yeah.
get with you after the end. Thank you.
But that definition is not changed on this bill.
Thank you.
The particular examples you have there in Jefferson County, though, are people driving, in excess of 80, 90, 100 miles an hour on
Public roads.
Dixie Highway or
Right.
wherever it may be, which
Expressway, Dixie Highway, communities.
at any time of the day, probably.
Yes.
Yeah. We do have a motion and a second. No other members seeking recognition. Mr. Clerk, please call the roll.
Representative Banta.
Yes.
Representative Ballman. Yes. Representative Blanton. Aye. Representative Burke.
Yes.
Representative Decker.
Yes.
Representative Dietz.
Yes.
Representative Flannery.
Yes.
Representative Griffey. Yes. Representative Kulkarni. Representative Lewis.
No.
Representative Maddox. Representative Marzian. Representative Moser.
Yes.
Representative Nemus.
Yes.
Representative Petrie.
Yes.
Representative Roberts.
No.
Representative Stevenson.
Yes.
Representative Whitaker. Representative Williams.
Yes.
Representative Wilson. Chair Elliott.
Aye.
Get this thing on.
So with 16 yes votes, 2 no votes, and 1 pass vote, House Bill 425 is favorably passed. So congratulations, Representative, and we'll hope this gets through the whole process. Thank you. The next item we'll have is the first item that's listed on our agenda, House Bill 78, an act relating to firearms liability protections and declaring an emergency. Representative T.J. Roberts. All those in favor of adopting the sub, please say aye. Aye. Those opposed, no. And the sub is adopted. You may proceed.
Thank you, Mr. Chairman. Representative T.J. Roberts from House District 66. The committee sub for House Bill 78 is simply clarification language. This was largely done in conjunction with the Kentucky Justice Association to make sure that there's still adequate avenues for instances of true negligence involving sellers, instances of like they knew or should have known the buyer is a convicted felon, fugitive from justice, issues along those lines. So that way there is at least that warranted avenue for recovery in those areas. But what House Bill 78 comes from is the need for a little bit of statutory history. In 2005, Congress enacted the Protection and Lawful Commerce in Arms Act of 2005, also known as PLACA. So this federal statute makes clear that the purpose was to protect from vicarious liability members of the firearms industry who engage in the lawful design, manufacture, marketing, distribution, importation, or sale of items pertaining to the Second Amendment. Simply put, Congress found that these items are heavily regulated by federal, state, and local laws such as the Gun Control Act, the National Firearms Act, the Arms Export Control Act, and other statutes that have been adopted since the codification of PLACA. They held that those statutes sufficiently regulated, and that if you are a manufacturer or a seller, you're following these laws. Generally speaking, individuals should not be held liable due to unforeseeable instances in which people use these items in an improper manner. Further, it is the intent of PLACA to only protect the law-abiding manufacturers and sellers that are done in compliance with these regulations. But there is a predicate exception, which is extraordinarily broad, and federal courts have warned about the broadness of these issues. The Second Circuit in City of New York versus Beretta made clear that there is a broad reading of PLACA that allows for the statute to ultimately be swallowed by the predicate exception, creating an instance where general laws that go well beyond the scope of the regulation of firearms or ammunition are being put on through judicial fiat. House Bill 78 simply incorporates the federal standards to the state level and just clarifies when we as a legislature believe the court should be able to intervene.
There's a motion and a second. Is there any discussion among the members? Seeing none, Mr. Clerk, please call the roll.
Representative Banta?
Yes.
Representative Ballman?
Yes.
Representative Blanton?
Aye.
Representative Burke?
I'd like to explain my vote, please.
Yes, please.
I can't think of a single time that I'm going to vote in favor of a gun manufacturer, so I can't be a yes. I have to be a no. I wish that we spent more time on protecting people from gun violence and less time on protecting the people who manufacture the guns. Thank you.
Representative Decker?
Yes.
Representative Dietz?
Yes.
Representative Flannery?
Yes.
Representative Griffey? Yes. Representative Kulkarni? Representative Lewis?
Yes.
Representative Maddox? Representative Marzian? Representative Moser?
Yes.
Representative Nemus?
Yes.
Representative Petrie?
Yes.
Representative Roberts?
May I explain my vote very briefly?
Yes, please.
Thank you. Mr. Chairman, House Bill 78 protects an industry from liability that has brought in at least $964 million to the Kentucky economy in just 2023 alone, and supports nearly 5,000 jobs at a minimum. This includes across Kentucky, and we have to make sure that that industry exists in order for this constitutional right to continue to exist. This is similar to our anti-SLAPP statute to protect the First Amendment, so I'm a yes.
Representative Stevenson?
Explain my vote, please.
Yes, please.
Most of what these manufacturers are being sued for are foreseeable, and they choose not to correct the deficiency. And yes, there might be $94 million and 5,000 jobs, but it doesn't compare to the loss of life because no one is being responsible for their actions. The people making the guns, and I have a gun, I don't mind, have one. But we've got to be more responsible. And this body has been unwilling to say, stop killing my children in schools. So I'm a no.
Representative Whitaker? Representative Williams?
Yes.
Representative Wilson? Chair Elliott?
Aye. So with 16 yes votes, 3 no votes, and no pass votes, House Bill 78 is passed, as amended by the sub, is passed with favorable expression. Congratulations.
Thank you, Mr. Chairman.
The next item, it will be House Bill 541, an act relating to peace officers, Representative John Blanton. There's a motion and a second on the sub. All those in favor, please say aye. Aye. Those opposed, no. And the sub is adopted.
Good morning, Mr. Chairman, members of the committee. John Blanton, representative for the 92nd District, and I will allow my guests to introduce themselves before we begin. We'll start down here on the far left.
Scott Tracy, I'm the Assistant Chief of Police at the Frankfort Police Department.
Representative Erica Hancock here in the 57th District.
Rob Ratliff, I'm the Executive Director with the Kentucky Law Enforcement Council.
Keith Jackson, Secretary of the Department.
And I want to thank my guests for being here with me on this piece of legislation today. This is a bill that both cleans up the functions of the Kentucky Law Enforcement Council and it strengthens our peace officer certification. And with that, I'm going to turn it over to the director, and he can brief us on the details.
Like you said, it's a cleanup bill that, back on.
And you have 10 minutes, so that's
Okay.
started.
It's a cleanup bill that cleans up the functions of the Kentucky Law Enforcement Council and strengthens peace officer certification. There's still a need to clearly define and separate KLEC processes and functions from the Department of Criminal Justice Training. This cleanup language is at the request of both agencies. So the proposal moves the authority from the DOCJT Commissioner to the KLEC Director to approve and authorize extensions for training for basic and in-service training.
There's a motion and a second on House Bill 541 as amended by the committee substitute. Is there any discussion amongst the members? And is there anything you'd like to add, Representative Hancock?
No, I want to thank the sponsor here for including our language, some concerns that Chief Tracy brought to me this summer regarding lateral movement within the system, not proper background checks being done. So I just appreciate the sponsor for including that.
Mr. Secretary, you want to add
Mr. Clerk.
anything?
Anybody else want to chime in? Okay. Mr. Clerk, please call the roll.
Representative Banta.
Yes.
Representative Ballman.
Yes.
Representative Blanton.
Aye.
Representative Burke.
Yes.
Representative Decker.
Yes.
Representative Dietz.
Yes.
Representative Flannery.
Yes.
Representative Griffey. Representative Kulkarni. Representative Lewis.
Yes.
Representative Maddox. Representative Marzian. Representative Moser.
Yes.
Representative Nemus.
May I briefly explain? Mr.
Yes,
Chairman?
please.
Yeah, want to say thank you for bringing this bill 100% forward. I also note, because some of my friends on the other side mentioned the bill before, that we've not done anything on weapons training. So I wanted to note that we're doing a lot of things on police training and make it easier for police. We've also passed a bill that said that if you commit a crime with a deadly weapon, you have to serve 85%. You're not eligible for early release. If you use your minor in a crime, you're going to get convicted of that particular offense, which was a major problem with the adults using children. We're allowed to destroy weapons now that have been used in violent crimes. All those things were House Bill 5, which my friends on the other side all voted against. So we've done a lot on putting gun violence in play and to take it very seriously. I'd also say that we need to do another thing, which is to hold our judges accountable who are releasing so many of these people who are engaging in violent crime early on shock probation and other things. Thankfully for the Safer Kentucky Act and House Bill 5 that the majority party voted for, I think it was a straight party vote, we've done a lot on gun crime and we need to do more, but we have done a great deal. Thank you, Mr. Chairman. Yes on this bill.
Representative Petrie.
Yes.
Representative Roberts.
Yes.
Representative Stevenson.
explain my vote.
Yes, please.
I think this is a good bill, and as my colleague from the other side of the aisle said, House Bill 5 did some things, but it didn't do enough, and it arrested homeless people without any resources. So let's stop the brava and focus on solving solutions for Kentucky families. Yes.
Representative Whitaker. Representative Williams.
Yes.
Representative Wilson. Chair Elliott.
Aye. So with 19 yes votes and no votes and no pass votes, House Bill 541 is passed with favorable expression as amended by the substitute. Congratulations.
Thank you,
for
Mr.
being
Chairman,
here.
and thank you to the members of the committee and to my guest.
Thank you.
Thank you all for being here this morning. House Bill 338, an act relating to forcible entry and detainer. Representative Susan Witten, please come forward.
Motion on the sub. Second.
There's a motion on the sub and a second. All those in favor of adoption, please say aye. Aye. Those opposed, no. And the substitute is adopted, and you may proceed after introducing yourself.
Thank you, Chairman Elliott. I'm Susan Witten, State Representative for District 31 in Louisville.
And my name is George Eklund. I work as the Director of Education and Advocacy for the Coalition for the Homeless in Louisville, Kentucky.
Thank you. I just wanted to explain the committee sub just for clarity. The committee sub is the result of countless conversations with the Apartment Association, the Administrative Office of the Courts, the District Court judges, and the Circuit Court clerks. The committee sub does several things. It provides a workable process that can be implemented in each courthouse around the state, including extending the clerk's time frame to comply to 45 days. And it ensures that we are not placing undue burden on a landlord in the event of a minor being listed. So Chairman Elliott, Vice Chair Decker, and committee members, I want to thank you so much for this opportunity to present House Bill 338 to you today. As the Housing Task Force co-chair of the past 2 years, we've worked hard to identify state-level solutions to Kentucky's housing crisis. While most of the solutions have been to address the housing supply, there are other solutions that we identified that can help eliminate unnecessary roadblocks for Kentuckians to have access to housing, especially affordable housing. And one such solution is addressed in House Bill 338. House Bill 338 requires the automatic expungement of dismissed eviction filings and protects minors from being listed in eviction cases, as well as providing a framework to remove their name from the record. Mr. Chairman, this bill has been years in the making, and I want to thank, again, the Apartment Association, AOC, the District Court judges, Circuit Court clerks, and countless advocates who have helped develop this legislation, especially through countless revisions the past 3 months. Now, this is not a unique piece of legislation, as 21 other states have already passed similar legislation, including the likes of Utah, Indiana, Idaho, Nevada, and Texas. And just last year, Ohio passed the youth provision of this bill. This bill is important as it increases the ability for working Kentuckians to have access to safe, affordable housing while explicitly maintains the property rights of the landlord. This bill makes no changes to the eviction, collection, or damage claims property owners may have. And I want to be very clear with this. This bill in no way takes away any avenues of recourse of the landlord. Landlords can continue to screen tenants based on references and legal criteria like proof of income or credit scores. They can still file evictions, they can still collect unpaid rent, and they can still pursue other legal claims or seek charges for property damage. This bill simply removes a barrier for tenants with dismissed eviction cases that would otherwise be a hindrance into finding available and affordable housing.
Motion and a second. Any comments, Mr. Eklund?
I have no comments. I just really appreciate the collaborative nature of this bill from the departments, AOC, the clerks, and the judges.
Thank you. Well, I have to recognize all the folks I see with green shirts on today who are welcome to the committee, and thank you for being here, and we appreciate your advocacy on this issue. Does any member seek recognition to discuss? Okay. If not, there's a motion and a second. Mr. Clerk, please call the roll.
Representative Banta.
Yes.
Representative Bauman.
Yes.
Representative Blanton.
Aye.
Representative Burke.
Yes.
Representative Decker.
Pass.
Representative Dietz.
Yes.
Representative Flannery.
Yes.
Representative Griffey.
Yes.
Representative Kulkarni. Representative Lewis.
Yes.
Representative Maddox. Representative Marzian. Representative Moser.
Yes.
Representative Nemus.
Yes.
Representative Petrie. Representative Roberts.
Yes.
Representative Stevenson. Representative Whitaker. Representative Williams.
Yes.
Representative Wilson. Chair Elliott.
Aye. So with 16 yes votes and no votes and 2 pass votes, House Bill 338 is amended by the committee substitute is passed with favorable expression. So congratulations.
Thank you, Chair. Thank you, Committee.
Thank you.
So the last House bill, if I'm handling things properly, is my bill. That's House Bill 780, an act relating to recording of deeds. And I'm just going to keep my seat, and I'm going to invite my guests forward, and I'm going to make a motion. Well, you can. Please do. And I am Daniel Elliott. I'm the chairman of the committee and the representative for the 54th District and the sponsor of House Bill 780. So if you two would introduce yourselves.
Gracie Kelly with the Kentucky League of Cities.
Steve Kyle, Fire Chief for the City of Paducah.
Well, thank you for both of you for being here. And House Bill 780 addresses a practical issue that cities across the state encounter increasingly when dealing with properties transferred through judicial sales. Under current law, a deed issued by a master commissioner must be recorded by the grantee within 5 days of purchase. However, in practice, some grantees fail to record these deeds, leaving property ownership records outdated and unclear. And when a deed is not recorded, cities may not be able to determine who is responsible for maintaining the property. This creates challenges for local governments seeking to issue correction notices, condemnation notices, citations, or liens related to code enforcement and public safety. This bill clarifies that if a property has a commissioner's deed and has not been recorded within 30 days of business of receipt, the city may petition the local circuit court to compel the filing of the deed, and the court may also award court costs, attorney's fees, impose fines or penalties as appropriate, and grant any other relief necessary to ensure compliance. Importantly, this legislation does not create new property obligations. Instead, it provides cities with a reasonable enforcement tool to ensure property ownership records are properly updated, which enables local governments to carry out their responsibilities. And for those reasons, I respectfully ask for the committee's favorable consideration of House Bill 780.
Motion on the bill.
And I'm happy to answer any questions. And there's a motion and a second, and I would yield to my friends for any comments they may have.
Well, thank you, Chairman Elliott, for carrying this bill. This is an important bill, and if you don't mind, I'll let Chief Kyle explain a little bit about why this is needed and some issues that he's had in Paducah specifically.
Absolutely. You've come a long way, so we want to hear from you.
Thank you, Mr. Chair. I appreciate the opportunity to speak and before the committee, and appreciate you all hearing the bill. You highlighted the problems that we experience on a day-to-day basis just with the lack of the recording of the deed in a timely manner, and it really does inhibit local government from being able to follow the process and make sure properties are maintained as they're supposed to. And we just appreciate your consideration for that and help us in this administrative process to clean up this language to make this process easier. Thank you.
And thank you for coming. That's quite a drive. I was in Paducah in November, and it's a beautiful city, but it's a long drive, isn't it?
Thank you, Mr. Chair. Yes, it is.
Does any member have questions or comments or seek recognition? Okay. If not, Mr. Clerk, please call the roll.
Representative Banta.
Yes.
Representative Bauman.
Yes.
Representative Blanton. Representative Burke.
Yes.
Representative Decker.
Yes.
Representative Dietz.
Yes.
Representative Flannery.
Yes.
Representative Griffey. Representative Kulkarni. Representative Lewis.
Yes.
Representative Maddox. Representative Marzian. Representative Moser.
Yes.
Representative Nemus.
Yes.
Representative Petrie. Representative Roberts.
Yes.
Representative Stevenson. Representative Whitaker. Representative Williams.
Yes.
Representative Wilson. Chair Elliott.
Aye. So with 18 yes votes, no votes, and no pass votes, House Bill 780 is favorably passed. So congratulations and thank you for being here. And the final item on our agenda today is Senate Bill 170, an act relating to status offenses. And we have Senator Brandon Storm, who is the chairman of the Senate Judiciary Committee, with us, and we're glad to have you and welcome. I guess
Thank you,
it's,
Mr. Chairman.
it's welcome back, isn't it? Because we're all together in the interim, and so it's welcome back, and thank you for being here.
Thank you, Mr. Chairman.
And if you would introduce yourselves.
Thank you. Senator Brandon Storm, 21st District.
Ashley Clark, Executive Officer, Department of Family and Juvenile Services at the Administrative Office of the Courts.
Jason Nemus, District 33, Jefferson, Oldham, Shelby Counties.
Please proceed.
Thank you, Mr. Chairman, members of the committee. Today, I want to talk to you about Senate Bill 170, a bill grounded in one simple belief. When a child struggles with attendance, the answer is early intervention and family engagement. Over the past several months, I've worked side by side with school superintendents, directors of pupil personnel, county attorneys, judges, and the Administrative Office of the Courts. I also want to recognize my colleague, Representative Nemus, who's worked closely with me on the legislation. The bill reflects our shared commitment across chambers to early intervention, family engagement, and a smart approach to truancy and status offenses. We examine what was working, what is not working, and where our statutes are inconsistent or outdated. The legislation reflects the collaboration across education and justice systems. First, the bill establishes the SOAR Truancy Prevention pilot program in 10 school districts. It brings together a RISE interdisciplinary team within the school. Second, the bill strengthens diversion by making it a family diversion, not just an agreement with the child. Third, we require the Kentucky Department of Education to report data annually so this body can evaluate whether court involvement actually improves attendance. Good policy must be framed by good data. Finally and importantly, we address secure detention of status offenders.
There's a motion and a second, and I'm going to let you finish your remarks, Mr. Chairman, if you want to.
That was the end of my remarks, Mr. Chairman.
Wonderful.
Thank you.
Wonderful. You know, we of course heard in JJOC the retired district attorney from Mobile County, and he had a very compelling presentation, and I know you observed and went there and saw what they had done. And the implementation of that here, I think is something that we can do. And so I credit both of you for moving this legislation forward. And I think, you know, it seemed like in his presentation that when the call or the letter or the interaction with the parent came from the district attorney, that it had quite a different effect than what our current statutes and our current system has here. So I think that this is a pilot, obviously, so it's going to be done in 10 districts, and we'll see how it works. but I think it's worth trying.
Absolutely.
Do we know the 10 districts that will be chosen?
We do not at this time. It would be selected by the Chief Justice.
Okay. Representative Marzian.
You almost answered my question, Mr. Chair.
Okay.
But so there's going to be 10 districts, and you said they'll be chosen by the AOC. So how will the districts apply, or will there be a process to go through, or will it be geographically located, or how?
Certainly. As Senator Storm mentioned, we have taken a multidisciplinary approach to looking at both Mobile, Alabama's model and then how our juvenile justice system is structured. So we would have to have prosecutorial buy-in. So we would be reaching out to that association, also working with our Director of Pupil Personnel Association to determine where those school districts that are very interested, engaged, and what their truancy data looks like and chronic absenteeism numbers look like, because we would want to ensure we had both rural and urban representation within the pilot.
Yes, please.
Thank you, Mr. Chair. Will there be any grant money or federal or state funds or KDE funds or ALC associated with being chosen?
Certainly, we have provided both Senator Storm and Representative Nemes a fiscal impact to this bill, because it will take additional court-designated workers to perform these duties. No. No.
The incentive for the school is, we pay for, educating the kids, but we pay for schools by seat for average daily attendance. And when in our county, Representative Marjan, when over 35% of our kids are habitually truant, there's a lot of money that JCPS is losing out on. And this is a small point, but I will note that it's not chosen by AOC, it's chosen by the Chief Justice. Small difference, but an important difference.
And she'll do a fine job, we know, in choosing those districts. And I would encourage those county attorneys, when those districts are chosen, to cooperate in this process, because, as you said, we have to have their buy-in and their support. And I think that's an important part of this equation. Representative Ballman.
Thank you, Mr. Chairman. And Senator Storm, thank you for bringing this bill. Representative Nemes. And I was curious, when the motion came, you were just starting some commentary around secure detention for status offenders. And I was wondering if you could finish that commentary to let us know exactly what you're planning to do here with this bill.
Sure. Thank you for the question. So as it relates to the status offender issue, I was going to turn that over to Representative Nemes, because what we've done is we've merged the two bills together to have one, bicameral product, and I'll let him go ahead and address that.
You can outline that if you want, Representative Nemes.
Yeah, I think that's Section 10 if my memory's right. So anybody under 14 will not be able to go. The cabinet has to put a place for them that they can be held. The secure detention facilities, anybody over 14, 7 days. If it needs to go longer than that, then the judge will make a written finding that needs to happen. I would note that I think the best part of the bill for me, there was a lot of really good parts of it, but for me, we're going to transition from focusing on the child to focusing on the family. And so the CDWs are going to have a family plan that they've already kind of put together. And then if there's a problem, the kid's not going back to school or whatever, the CDW is going to figure out why that is. And it could lead to a dependency, neglect, and abuse referral being made to the cabinet, because, if you've got a 14-year-old that's not going to school, okay, fine, it's the kid's got some fault there. Where's the parents? What are they doing? They need accountability, and this brings accountability to the parents. We need more accountability than what this bill brings, but this brings a lot of accountability to the parents for not parenting their kids.
Thank you for that response. Thank you, Mr. Chairman.
Thank you, Representative. Does any other member have? Representative Dietz.
So, thank you, Mr. Chair. I know one of the issues that we've had in our courts in Northern Kentucky surrounds mental health and kids that are struggling with mental health, and the prosecutors prosecuting for truancy when they're at home. So I'm hoping that this work will allow these kids to get the help that they need without being charged, or the parents being charged with truancy, so the kids can get the help they want. Because I know I've represented a handful of these kids and have worked with, it was Children's Home of Northern Kentucky that really help with these situations, but the number of prosecutors that were prosecuting these kids was unbelievable. So I'm really hopeful, and maybe you all can let me know if you think this is something that will help on that front end.
Certainly. So we know early engagement with these families is key. And so getting them those access to those services and supports and, telling those community partners, this is our need right now in this individualized school. And then the RISE team that's in here within this legislation, those are the movers and shakers, not at a big system level of the community, but actually they have hands and eyes on these children day in and day out. So we would hope to mobilize those supports very early on versus waiting until the court's involved.
And also, just to echo that, we put a provision in here that we want to collect that data. And so anytime a child is involved in the court system, we want to track that data and we want them to report back to this interim committee. And that way we can study it. And we want to see every time a student was basically brought into the court system and then withdrew from the school system, we want to know how often that happens and really why, the root of the problem, why it's happening. Thank you for the question.
One of the comments that struck me during our JJOC meeting during the interim from the retired district attorney from Mobile County was that he considered any truancy that ended up in court a failure of the system, because that child was then more likely to have all kinds of problems as an adult. And so if you can head that off, which is what this bill's trying to do,
Mr. Chairman, there was
you can have an educational outcome that sets that child up as a successful adult. But go ahead, Bruce.
Mr. Chairman, to your point exactly, there was a study from Miami-Dade County that found that their serious offenders, 75 to 85% of their serious offenders had been truants, had a history of truancy as low as the third grade. And the United States Department of Juvenile Justice put it as clear as it can be possibly put, and that is truancy is the first step. It doesn't cause it, but it's an early indicator. It's the first step toward a lifetime of unemployment, crime, and incarceration. So if we can get that kid and their family early, we can stop. It's also a public safety measure as well. But we're trying to get the kid on track so they can have happiness in life, success, but also so we don't have victims in the future that this person is on the wrong track to commit crime. So I think it's right in line with what you're saying.
Thank you. Any other member? If not, we will call the roll.
Representative Banta.
Yes.
Representative Ballman.
Yes.
Representative Blanton.
Aye.
Representative Burke.
Yes.
Representative Decker.
Yes.
Representative Dietz.
Yes.
Representative Flannery. Representative Griffey.
Yes.
Representative Colcarney. Representative Lewis.
Yes.
Representative Maddox.
Yes.
Representative Marzian.
May I explain my vote?
Yes, please.
I'm a yes, but I wish it was more than 10. Thank you.
Representative Moser.
An enthusiastic yes.
Representative Nemus.
Yes.
Representative Petrie. Representative Roberts.
Yes.
Representative Stevenson. Representative Whitaker. Representative Williams.
Yes.
Representative Wilson. Chair Elliott.
Aye. So with 17 yes votes, no votes, and no pass votes, Senate Bill 170 is passed with favorable expression. So congratulations.
Thank you, Mr.
And
Chairman, members of the committee.
Thank you, Mr. Chairman. Yes, and I will recognize Vice Chair Decker for recognition of a guest.
I see a whole line back there on the back row that just walked in from Shelby County Farm Bureau, and I want to welcome you here today. Thank you.
Thank you for being here. And so I want to thank the members of the committee for their cooperation with hearing 8 bills in an hour and 5 minutes. That may be a record here, to do it that quickly and expeditiously. And as John Wooden said, be quick but don't hurry. And I think that's what we